This is Mary Page from Chicago, and welcome to our next Rights in Russia interview on the situation for human rights defenders in Russia. Today, our guest is Jessica Gavron, Legal Director at the European Human Rights Advocacy Center, where she has had extensive experience litigating cases from Russia before the European Court of Human Rights. Thank you for joining us, Jess, and sharing your perspectives on the situation for present-day human rights defenders in Russia, and in particular, how the European Human Rights Court impacts their work. I have some questions I'd like to pose to frame our interview, which we hope to complete in about 30 minutes. So let's get started with my first question. Could you briefly describe the aims and work of the European Human Rights Advocacy Center, please?
Hi, Mary. Thank you for inviting me on this very interesting podcast. Yes, certainly. So we call ourselves EHRAC because otherwise it's a bit of a mouthful. And we're an independent legal centre based at Middlesex University in London. And we litigate strategic cases of serious and systemic human rights abuses before international tribunals and regional tribunals, mainly actually the European Court of Human Rights. And EHRAC was established in 2003 to litigate cases from the Chechen conflict concerning the aerial bombardment of villages like Kachayurt and many, many cases of enforced disappearance, which we did with Memorial Human Rights Center, our main partner in Russia. And we then expanded into the whole of Russia and we addressed wider human rights abuses. So we now work across 5 countries in the former Soviet Union: Russia, Georgia, Ukraine, Azerbaijan, Armenia, and we work in collaboration with partner lawyers in these countries, so mainly with NGOs, but for instance in Azerbaijan, where the NGO laws are so restrictive that NGOs can't really operate, we work with individual lawyers there. And we're still quite a small team of international human rights lawyers, so there's about 5 of us, and some legal consultants and a fellow from the region, and we have NGO program and communications experts. And the way in which we work is quite unusual. We collaborate very closely with our partners on each case. So the local partner will provide the domestic context expertise on the domestic laws, and we provide international expertise, and we mentor the partner through the process of legal argument, gathering evidence, and procedure. And to date, we've litigated hundreds of cases across specific thematic priorities arising from our region in which we work. So of course, conflict, we began with conflict, and sadly, conflict has carried on to be an issue for the whole time, really, the whole period we've been working, seeing new conflicts or newly active conflicts in South Ossetia, in Eastern Ukraine, in Crimea, and in Nagorno-Karabakh. Security force and law enforcement violations are also systemic in our region, as is repression of civil society and the foreign agents law. I'm sure you're familiar with. We've challenged that. We've also taken a lot of cases supporting human rights defenders and actually lawyers, colleagues, our partners in Azerbaijan as they've become victims of persecution and harassment. And then another major focus is discrimination against the LGBTQ community, which is very marginalized across the whole region. And we have a particular focus on violence against women and girls because the laws in the post-Soviet space on domestic and sexual violence are generally pretty inadequate, and there are a lot of discriminatory investigative practices as well as stereotyping, all of which create barriers to justice. We also push for the implementation of our cases, both within the mechanisms of the Council of Europe and where possible, engaging domestically with and through our partners. So to come back to your question, our aims are to challenge gross human rights abuses and obstacles to justice by achieving higher standards of protection and increased access to justice for our applicants and for marginalized communities, and to increase the skills of our partners litigating cases before international tribunals.
So, excellent. When exactly can a Russian citizen apply to the European Court of Human Rights?
Well, that's a good question. And I think this is quite an amazing and empowering thing about the European Court of Human Rights, which is that any Russian citizen or any citizen of any country, any person living in a member state of the Council of Europe can bring a case to the European Court of Human Rights and can get a binding judgment against their state. But it's also a good question because there are a few basic requirements that they must fulfill. So firstly, and most obviously, they have to be a victim of a human rights violation, which means they have to have directly suffered as a result of the action or inaction they're complaining about. And the action or failure to act has to be attributable to the state. So there are a number of ways in which a state might be responsible. For example, one of its agents might be responsible for police brutality at a protest, and that would be what's called the negative obligation, an obligation to refrain from interfering with your rights or physically harming you without justification. Or it might be a failure to investigate a crime committed against you, or it could be a failure to enact adequate legislation so that caused you to suffer harm. So I just was talking about violence against women. For example, one thing we're trying to challenge at the moment is the lack of a consent-based definition of rape in Russia and across our region, with the consequence that rape is understood very restrictively on the basis of use of and evidence of physical force. And therefore, many rape crimes aren't prosecuted or aren't even recognized as rape. So then just to come back, once you can show that you've been the victim of a violation for which the state has some responsibility, you have to have exhausted domestic remedies in the national system. And that's because the European Court of Human Rights is a subsidiary jurisdiction, meaning that national courts or mechanisms must have the opportunity to provide redress to an individual. And only once you've given them that opportunity and they've failed, can you take the case. So in fact, in summary, it's pretty simple to take a case. It's pretty straightforward. You don't need to instruct a lawyer. An applicant can fill in the application form on the court's website. The huge numbers of cases brought by applicants from Russia, for example, testify to this. They should, of course, be warned that it can take many years for the court to process the case. But when a person has been failed at the domestic level and has been completely sidelined in their own community, in their own country, whether they're a mother in Chechnya bringing a case about the disappearance of their son, or a transgender person who's denied basic rights, the fact that they can obtain a judgment that's not only binding on their government, but has the potential to set standards across all 47 member states is a testament to the influence of the court and its strength, really.
When you get a ruling from the court, does Russia implement those rulings?
Well, that's a critical question, and not my favorite question.
All right.
Russia hasn't implemented more than 80% of leading judgments against it. On average, these cases are pending for 7 years, unimplemented, and in the majority, it doesn't even submit an action plan. So it is problematic. The issue with implementation is completely different to that of litigating the case, which is a legal process. Implementation is primarily a political process. It relies on political will of the government and the governmental bodies in question. And there's very little political will in Russia to implement the majority of the judgments against it, as many of these concern violations that are considered political or sensitive. Another issue is that the Committee of Ministers, the body at the court in the convention system that oversees the implementation of judgments, is also a political body. It's or diplomatic body, depending on how you want to call it, comprising of representatives of each of the governments of the member states, who are therefore restricted by their own government's position on a particular issue, or compromised by their own government's failure to implement a judgment against it. So it has inherent constraints, or you might want to call them flaws. But nonetheless, judgments are binding on member states. Implementation requires two different types of measures, individual measures, which is the payment of compensation and sometimes other measures to put an applicant back in the situation existing before the breach, like a retrial, and also general measures to combat repetitive violations of the same sort, by making policy or legal, legislative or practical changes. To be fair, there are cases Russia has implemented. So, for example, Berdov against Russia was a pilot judgment with respect to non-enforcement of domestic judgments, which is a systemic issue across the region in the post-Soviet countries. And Russia has introduced a new law on compensation to deal with violations of fair trial and enforcement of judgments within a reasonable time. Other cases have resulted in increased protections for persons subject to involuntary psychiatric hospitalization by allowing challenges to decisions about incapacity. And I think there's also various amendments with respect to fair trial, introducing new circumstances as a basis for appeal, and increased access to courts. But within the cases we take, which are generally quite political and concern repressions of civil society or security force violations that I've just outlined, we don't really see any willingness to implement in any meaningful way. So, for instance, the cases that I mentioned, the hundreds of cases or almost 100 cases we've taken from Chechnya, which concern egregious violations of human rights, the right to life or torture, haven't resulted in any effective investigations. No one's been prosecuted or punished, despite the fact that actually many of the perpetrators have been identified or are identifiable, and no information has been provided to applicants about the fate of their relatives. Russia does, it should be said, pay compensation usually. So in these Chechen cases I've been talking about, Russia pays. In the Beslan school siege case, which I'm sure you and your listeners will know about, when Chechen separatists took over a school in North Ossetia and held school children and some of their parents hostage for 3 days. And then there was Russia intervened and a large number of people died, children lost their lives. The court awarded nearly 3 million euros in compensation to the applicants, and Russia paid it. And that's not insignificant. The problem is that sometimes the authorities can use compensation as an obstacle to other requirements. So the authorities might say, well, we paid the compensation, what else? We don't need to do anything else. Almost like it's a tax on their lawless behavior. Perhaps we might see movement in areas like violence against women. There are really vocal local Russian activists on this who've been campaigning for domestic violence legislation for years. There are some great lawyers taking cases to the European Court of Human Rights in Russia and to the CEDAW committee. And these issues seem to be getting more coverage, more media coverage, and being on the agenda a bit more. And a strong progressive judgment like Volodina creates a platform and perhaps some momentum for change. But there's also huge pushback on this issue from the Orthodox Church and politicians who campaign on so-called traditional values. So we'll have to see. I mean, for us, implementation and the lack of it is a huge issue for the Council of Europe, for the credibility of the convention system and for its efficacy in order to stop repetitive cases that flood the court. And there's an increasing number of illiberal or authoritarian states who resist the human rights discourse. And of course, it's not just those states who do this. It's not helpful that the UK has refused to implement judgments such as on prisoner voting because it compromises its position in the Committee of Ministers. And its ongoing sporadic threat to withdraw from the convention for domestic political purposes is also hugely problematic and has repercussions around the region, including in Russia. So it's a difficult subject.
So does the Human Rights Advocacy Center have a specific approach to implementing cases in this difficult environment?
Well, we do still engage with the Committee of Ministers because it's really important that civil society keeps the pressure on this process and uses it to hold states to account. Without civil society engagement, many cases wouldn't be, would go unexamined, or action plans, government action plans would be uncontested. So we do continue to push as well for more transparency and more routine engagement with civil society by the Committee of Ministers. And they are slowly waking up to the role of NGOs in the process. I think the Committee of Ministers needs to be far more robust with states. It needs to use the tools it has more forcefully. For instance, not be so reluctant to use infringement proceedings. It's letting the court down in that way. But it is worth persevering because you never quite know when an unexpected opportunity will materialize or open up for movement on a case. So for instance, in Azerbaijan, which if in anything is more repressive and authoritarian regime than Russia, and has been imprisoning human rights defenders and disbarring lawyers, and where generally there's very little prospect of successful implementation. In one of our cases that we've worked hard on, the political prosecution and conviction on trumped up charges of our colleague, human rights defender Rasul Jafarov, shortly after a robust judgment from the court, he was released from prison. And then last year, his conviction was quashed by the Supreme Court, which allowed him to resume his professional activities in full. And similarly, for the opposition politician Ilgar Mammadov, who was released, he was only released after about 7 years, once the Committee of Ministers initiated infringement proceedings against Azerbaijan, which is the first and last time so far that it's used this mechanism. But he's also subsequently had his conviction quashed, and those were significant developments and not necessarily what we expected, certainly with respect to Rasul. It's worth saying there are a number of other lawyers and human rights defenders whose convictions still stand, and we're petitioning the Committee of Ministers to continue to put pressure on for them. But after engaging with the Committee of Ministers for many, many years on the Chechen cases in particular, which I think are seen generally, even by the Council of Europe, as the most challenging of all the cases that are supervised by the Committee of Ministers. And after being told repeatedly that pursuing prosecution for enforced disappearances was something that was just too political, we've had to think of other ways of getting some form of resolution for our applicants. And while we are still engaging with the Committee of Ministers on humanitarian resolution, in particular, like things like identifying graves and storing DNA samples for future use, we have also made the strategic decision to refer these cases to the UN Working Group on Enforced Disappearances with the consent of our applicants. And the working group is a very different body. It's not a judicial body. It pursues humanitarian resolution only. It communicates the facts of the case to government and requests information. So it's almost like a conduit. And we wanted to use this mechanism in part to ensure that there's correct recording of these really significant cases and state practice in Chechnya, and also in the hope that a purely factual humanitarian route might yield some information for these families of the disappeared who've been living in this torturous limbo of unknowing for so many years that in itself has been found to be by the court to constitute inhuman treatment. We're also persuading the two bodies to communicate over these cases, which they both are seized of, which is a new development. So hopefully that might lead to some progress. Generally, our feeling is the more international mechanisms that engage with these cases, the more awareness there is and the more pressure is kept up. We basically recognize that the region in which we work is probably the most challenging for this issue. And so while we do prioritize key cases to really put the pressure on, we also have to acknowledge different forms of impact and take account of the fact that a successful judgment is a meaningful win. It constitutes a judicial reckoning and an account of state practice for the applicants, an acknowledgement that a state is responsible for the violation. When this has been repeatedly refuted domestically, that compensation can be very significant for people who've lost an income for all sorts of reasons, a source of income, that a case raises awareness and it's a platform for advocacy, and of course that it can set standards across 47 member states.
Sure, right. So could you just say a little bit about what the new changes in the Russian Constitution might mean for the work of the European Court of Human Rights?
Yeah, well, this has been, this is problematic, and it's been an ongoing saga since July 2015, when the Constitutional Court ruled that in exceptional cases, the court could deviate from its obligation to enforce a European Court of Human Rights judgment if it was found to be not compatible with the norms and fundamental principles of the Constitution, which was then enacted into federal law, allowing for a new internal review mechanism whereby cases could be appealed to the Constitutional Court where it was suspected that enforcement would contravene or contradict the Constitution. So we saw this put into use in 2016. The first case was a case of prisoner voting rights, very similar, ironically, to the issue in the UK, where it was held that the Constitutional Court couldn't implement the judgment. And many people seem to agree that the ruling in 2015, despite the fact it was used for this case, that in fact the ruling was in response to the 2014 judgment about the UKOS case, because that awarded an unprecedented, having said that Russia pays compensation, it pays it, and usually it's not a significant amount. But the amount of compensation to UKOS shareholders amounted to 1.9 billion euros, which Russia clearly had no intention of paying. And sure enough, in 2017, the Russian Ministry of Justice brought the case to the Constitutional Court and argued against its enforcement. And the Constitutional Court revisited its original decision that contradicted the European Court decision and concluded that the enforcement would contravene constitutional principles on equality and fairness of taxation rules. I think it's also notable, though, that the new approach by the Constitutional Court was introduced after Russia's annexation of Crimea, which was internationally condemned and is being challenged in various different international mechanisms, including the European Court of Human Rights, by Ukraine. So that may also have been a factor. Mm-hmm. And this development by the Constitutional Court is very much a departure from its own constitution, which Article 15.4 states that international treaties to which Russia is a party form an integral part of its legal system. And in case of divergence, those treaties should have precedence over international law. So I think what you're referring to, in March of last year, new amendments to the Constitution itself were introduced. And while Article 15 remained intact, a new version of Article 79 stipulates that decisions by international bodies shall not be subject to enforcement by Russia if they run counter to the Constitution. So it's still not quite clear how those two will be interpreted and operate together. But the obvious consequence of these amendments is that it creates uncertainty as to when Russia and whether Russia will abide by its commitments under international treaties, and not just the European Court of Human Rights, but other international treaties that Russia signed up to. It's quite difficult to know the impact on the European Court of Human Rights rulings, because although it's used this mechanism, it's invoked this new approach in 2 Russian cases, it actually doesn't, Russia doesn't in any event implement, as I've talked about, the majority of judgments from the court. So it didn't necessarily need to take this step. So I think we have to see how it plays out with really contentious cases, perhaps the interstate cases initiated by Georgia and Ukraine against Russia, and the conflict relating to the conflicts, and other international cases brought against Ukraine by Russia, and perhaps other, very political cases like the Navalny case or other cases like that.
It often seems that Russia is kind of an unwilling member of the Council of Europe. So how important is membership for Russian citizens? If you were looking at
I think it's really interesting that Russia does, as you say, it portrays itself and actually behaves in many ways as though it's an unwilling member of the Council of Europe, and yet it's still there. Russia has the most pending cases before the European Court of Human Rights. So clearly the court is used by Russian lawyers and applicants. And from what we hear from our partners and our applicants, the court is considered a final court of appeal. They simply feel they can't get justice domestically. So even Russian lawyers who are pretty cynical about the court and the implementation process still engage with it. So it clearly is seen to have value. It provides access to human rights standards, and it's a means of justice from an international court. I mean, I still think it's remarkable that an applicant can take their state to court. It's still only fairly recent, 1998, that Russians can do this. And as I've said, our judgment provides judicial record and some measure of justice and acknowledgement. I mean, I can give you an example of how important it can be. For instance, one of our applicants, Taisa Abakarova, was 8 years old when she was forced to leave her village in Chechnya because during the Second Chechen War, because the Russian military were bombing insurgents who were had entered the village, and her family left in a car, and they were waving a white flag, and they were in a sort of humanitarian convoy of refugees, all waving white flags. And nonetheless, their car was hit by a Russian airstrike, as were other cars, that killed her parents, her two brothers, her sister, her cousin, who were aged between 6 and 14. And she was severely injured, but she was the only survivor. And it was weeks before her aunt could bring herself to tell her that she'd lost her entire family. And she brought a case to the European Court of Human Rights against Russia with the support of Memorial and EHRAC. And eventually the court found violations in a very, very robust judgment, very critical judgment of Russia, found violations of the right to life with respect to herself and her family. And she was awarded €300,000 in compensation. And that judgment is really important. You know, that's the only recognition she's got of her loss and what happened to her, and the, you know, egregious behavior of the Russian state and military. So, I mean, whether Russia should remain in the Council of Europe is always the subject of much debate. And similarly with countries like Azerbaijan, when Russia joined in 1998, it was a controversial decision. Lots of strongly held views about it. It was the context of the Second Chechen War, the war I've just talked about, with gross violations. So it's totally understandable to question it. Generally, my view, and I think that of many human rights practitioners, is better in than out, because it creates more opportunity to influence and provide a measure of accountability, even if limited. Judgments are detailed, they're supported by evidence, so they're there and they can be used if at some point there's political will. And I think we saw the difficulties of this play out in the suspension of Russia over Crimea, where it's stripped of its voting rights in the Parliamentary Assembly in 2014, and then in 2017 it stopped paying its dues to the Council of Europe. It's one of the 5 largest contributors. And then in 2019, very controversially, it was allowed back in. And on the one hand, allowing Russia back in has been argued to show weakness, to undermine the credibility of the Council of Europe system. They gave into a bully. It sends signals to other states like Poland and Hungary and Azerbaijan that if you wait long enough, your egregious human rights abuse, your annexation of territory will eventually be overlooked. And these are really valid arguments. But on the other hand, it showed that Russia, which threatened to walk away numerous times during this whole debacle, actually does want to remain at some level in the system. And there were also heartfelt pleas from lawyers and human rights defenders and activists in Russia about how important it was for them and for ordinary Russians to continue to have access to the court and to these international human rights standards. Would it be better to stand on principle with the result of denying Russians the measure of justice the court provides on the basis that, you know, that it doesn't comply and that it's too authoritarian and does these, you know, things that are contrary to international law? Or bear in mind the origin of the convention system, which was to bring together European states to combat authoritarianism and uphold human rights for the citizens. These are really difficult questions, and these issues aren't going away as we see more fragile democracies become more populist and illiberal. And I think the court and the Committee of Ministers and the Council of Europe and the member states themselves need to engage really robustly with these states that are challenging the system.
So looking to the future now, and from the perspective of someone who litigates before the European Court of Human Rights, so how do you see future relations between the court and Russia developing?
Well, I think it's really difficult to know. Russia does still engage with the process, so it provides some amount of disclosure in cases. It responds to the court's questions in cases when asked by the court. And of course, as I've said, it generally pays compensation. There's been the ongoing threat of it leaving, not helped by the UK's position at times, but it hasn't left. That doesn't mean it never will. It certainly is becoming more repressive and authoritarian, so cases are likely to keep coming. And we'll have to see how the constitutional amendments play out. So far, I think Russia doesn't seem to be going anywhere, though. I suspect that it serves a purpose to be able to say it takes human rights seriously, to collaborate, cooperate with European states, while responding selectively to judgments. But we are in uncertain times. So we've just watched, just last weekend, we saw the president of Turkey withdraw from his country unconstitutionally from a Council of Europe convention on preventing and combating violence against women and domestic violence, and actually ironically named the Istanbul Convention. And Turkey was the first state to ratify that convention 10 years ago. And one would hope that protecting women from violence wouldn't be a political issue. And the withdrawal was based on the increasingly familiar argument we hear from these parts of the world about family values and the fear that the convention promotes homosexuality. And unfortunately, this is something echoed by other states like Poland. And these things can be contagious. So, it's difficult to predict what's going to happen. In terms of the court, in general, my impression is that over the last few years, we've seen more pushback by states generally, and more deference by the court to states. In some ways, this is, of course, partly a pragmatic approach by the court because it needs its member states to play ball. It also needs to encourage national jurisdictions to address human rights violations because, frankly, it's being overwhelmed by cases. So, for instance, we're seeing development circumscribing its role a little bit. So more proactively encouraging friendly settlements by the introduction of a new non-contentious phase. The recent interstate cases, the recent interstate case of Georgia against Russia, we saw the court limiting its role in conflict with respect to the active phase of hostilities. We've seen it requiring applicants in countries such as Hungary and Turkey exhaust domestic remedies through the domestic courts when nobody's under the illusion that these courts are independent when it comes to political cases. But with respect to Russia, in some way, the court's approach is simpler than the Committee of Ministers. It's a judicial body. It should be operating on a case-by-case basis. But there are decisions to be made about prioritization. So, for instance, how does that play out? We see, on the one hand, the recent interim measures decision ordering the release of Alexei Navalny on grounds of risk to health and life in prison. We've also seen, I have the impression over the last year that it's been expediting communication of domestic violence cases against Russia. But on the other hand, the foreign agents case, which is probably the most significant case against Russia domestically, is still inexplicably pending after 7 years, despite the fact that the foreign agents law has been crippling civil society in Russia and spawning numerous amendments that extend its reach to individual journalists and human rights activists, and the court hasn't played a role in that to date. So I think the court and the Council of Europe face serious challenges of how to tackle an ever-growing and unsustainable caseload and how to deal with the increasingly populist, illiberal, whatever you like to call them, states. And obviously these things are not unrelated. And it really needs member states to take the implementation of judgments seriously and to be proactive in the Committee of Ministers and get tougher on reluctant states. But then, in many ways, the court continues to do a phenomenal job of delivering strong judgments in difficult, complex cases that provide huge numbers of individuals with redress and sets human rights standards across the region, despite all the challenges it faces. So.
Well, thank you, Jessica. This has been a terrific and broad-ranging, rich interview. I'm afraid our time is up, but I want to thank you for making time for Rights in Russia and for sharing these insights. Goodbye, and wishing you the very best, Jessica.
Thank you, Mary. Thank you very much. It's been a pleasure.
Take care.